would if we were meeting in person. So I want to make sure everybody knew that. If you have any technical issues during the meeting, please either use the chat function to message Kelly Thibodeau or send an email to Megan. Again, either send through the chat function, send a message to Kelly Thibodeau or send an email to Megan Lavoie or Kelly. And if for some reason you get disconnected or have to leave the meeting, you may rejoin the meeting and you'll be admitted promptly. So I just wanted you to be aware of that. Some of the members of the legislature may have something coming up. I know the governor's scheduled something for later this morning with respect to the hopefully not incoming storm. So just know that if you can rejoin the meeting and you'll be admitted promptly. Let me mention a couple of useful tips on how to use Zoom. To mute or unmute yourself, select the microphone button on your device. That is on the lower left side of your screen. And we ask that you remain muted until you would like to speak. Moreover, to turn your video on or off, please select the video icon, which is also in the lower left side of the screen. Now, if you want to raise your hand to ask a question during the meeting, select participants, and then the hand icon will come up next to your name. Select the hand, we'll raise it, and selecting it again will lower it. So if you're calling into the meeting to mute and unmute yourself, you'll press *6. To raise your hand, you'll press *9. Now, this is a decision that I have made, but I thought it may make our meeting more efficiently. As the presenters make their presentation, you're undoubtedly going to have questions. I urge you that to help us manage the meeting more efficiently, please hold your questions until after each group's testimony. And then we can go through a question and answer period, which at least I think will be much more efficient and make our meeting go much more smoothly. So with that introduction, let me refer to the agenda, which was sent out to you previously. And Megan, could you please call the roll?
Yes. Okay. Chairman Beck?
Present.
Senator Birdwell?
Present.
Senator Hinojosa?
Present.
Senator Huffman?
Here.
Senator Nichols? Representative Hunter? Who I know is here. Representative Landgraf?
Present.
Representative Menares?
Present.
Representative Sherman?
Present.
Mr. Babcock?
Present.
Judge Jameson?
Here.
Chief Justice Jefferson?
I'm here.
Ms. Liberato? Mr. Oliveira?
Present.
Chief Justice Phillips?
Here.
We have a quorum.
Okay, thank you very much, Megan.
And I'm here. Todd Hunter's here. So.
Yes, thank you, Senator Representative Hunter.
All right, the next item on our agenda is the adoption of the minutes of our March 6, 2020 meeting. It's hard to believe it's been almost 3 months since our last meeting, but we just didn't think we could go forward with the last 2 meetings given the state of the pandemic at the time. So I decided that in consultation with my Vice Chair, Chip Babcock, that we needed to go forward with this meeting, even if it was by Zoom. We're under a legislatively mandated deadline, and I didn't think we could miss another meeting and still satisfy our objective. So with that understanding, let me move to item 3 on the agenda, which is the adoption of the minutes from our March 6, 2020 meeting. Those were sent out to everyone earlier. I hope you've had an opportunity to review those. I will entertain a motion that those minutes be adopted.
Move to approve.
All right, it's been moved. Do I hear a second?
Second.
All right, it's been moved and seconded. All those in favor of adopting the minutes from our March 6, 2020 meeting, please signify by saying aye.
Aye.
All those opposed, same sign. No opposition. All right, that brings us to the principal purpose of this meeting of the commission, and that is the testimony of various persons who have been invited to appear. Now, not everyone we have invited to appear has decided to appear, certainly not at this time. But we decided that we needed to go forward with as many people who were invited could in fact appear and make a presentation if they so desired. So with that understanding, let us begin with the first presentation, which is by Julie Lowenberg on behalf of the League of Women Voters of Texas. And I want to caution all the participants that each presenter will be limited to 15 minutes, and we've got an extra 5 minutes for questions and answers. And obviously, we'll take that by ear. We may need to extend it a time or two. But in any event, Ms. Lowenberg, if you would begin, we would very much appreciate it.
Thank you. I'm Julie Lowenberg, testifying as a member and on behalf of the League of Women Voters of Texas. The League greatly appreciates this opportunity to address the Interim Commission on Judicial Selection. And we applaud the 2019 Texas Legislature for passing the bill calling for appointment of the commission and charging it with considering the fairness, effectiveness, and desirability of selecting Texas judges through partisan elections. As noted last year by Texas Supreme Court Chief Justice Nathan Hecht, the current Texas system is among the very worst methods of judicial selection. When partisan politics is the driving force and the political climate is as harsh as ours has become, judicial elections make judges more political, and judicial independence is the casualty. A judicial selection system that continues to sow the political wind will reap the whirlwind. The Interim Commission has the opportunity to avoid the whirlwind by moving the Texas court system forward, away from big money and partisan elections, toward a fairer system for selecting the most qualified, fair, and impartial judges. The League has advocated a fairer system since 1965, when it adopted its position on judicial selection through consensus of our statewide membership, adding a few tweaks over the years. We are pleased that after a period of dormancy, the issue came to the fore in 2019, and that the Commission is taking on its charge with enthusiasm. The League of Women Voters supports an effective, independent, qualified, and inclusive judiciary for Texas, and calls for selection of specified judges in the following manner: nomination by a diverse, representative, nonpartisan commission with appointment for a specific term or appointment by the governor for a specific term. Judges should be subject to retention or rejection in an unlimited number of periodic nonpartisan elections. This selection method should apply to the Texas Supreme Court, Court of Criminal Appeals, and Courts of Appeals. Selection of state district court judges should be by nonpartisan election or by appointment retention. And judicial campaigns should be funded with public money. Thank you again to the Commission for this opportunity and for your commitment to serving the people of Texas. And that's all I have.
Thank you very much, Ms. Lowenberg. Questions by the Commission? I have one question, Ms. Lowenberg. You talk about this nonpartisan commission. Who would name the members of the nonpartisan commission?
Well, we hope to be rather flexible on whether if it was a proposed law, how the commission were to be selected. We've kept our position flexible so that we could support or oppose it, depending on what the criteria were for appointment.
Okay, thank you. Any questions by members of the commission?
Well, I had my hand up as well, and my question was very similar to the chairman's question. Has the league given any thought to the qualifications of such a commission, whether they should be lawyers, judges, members of the public, members of a specific political party, etc.?
I think you'll be hearing in the next testimony from the Fair Courts Network, of which the league is a member, some more about that. But in the first bullet of our position is that we would like a diverse, representative, nonpartisan commission. And I would hope that would include non-lawyers as well as lawyers and what it says in the bullet. So,
Thank you.
Okay. Any other questions by members of the commission?
I have one, Chairman. Good morning, Ms. Lowenberg. Thank you for being with us. We appreciate your participation this morning. Along the same lines of the questioning, I was wondering if you had any recommendations as to how many people should serve on the commission, a certain number. Any recommendation there?
that is not actually, yeah, we have not studied that, so I can't answer that specifically, but enough to make it diverse, nonpartisan, and representative is what I would say.
I appreciate that. Thank you.
Mr. Chairman, may I ask one question?
Yes, please.
This is Wallace Jefferson. Thank you very much for appearing. Could you talk to the commission about the difficulty, if you believe there is one, in communicating to the voters the qualifications and general merits of candidates currently for judicial office?
Yes, that is one of the most serious problems that we have with the way the partisan elections are conducted. You'll hear more about this again in the next testimony, but definitely voters need more nonpartisan information about the judges, about the judicial candidates.
Great, thank you very much.
Mr. Chairman, this is Chip Babcock. Could I ask a question, please?
Absolutely.
Thank you, Ms. Lowenberg. One of my issues is public, is funding of the contested elections. You propose public funding. Do you have a sense of how much money it would take to fund the races that you say should be done by election?
No, that has not entered into our studies, but no. The answer is no, I don't know.
All right, I have one other concern or issue with respect to the judges that are eligible for nomination by the commission that you've proposed. Is there any thought been given by your group to the incumbent judges, many of whom are just brand new from these last two election cycles? Any thought about how to protect them, or just they have to go back into the swimming pool, so to speak?
I would, again, it's not something we studied specifically, but I would think that a new system, a wholly new system like this would have to be phased in some way.
Okay, thank you so much. I appreciate it.
All right. Any other questions, Ms. Lowenberg, by the members of the commission?
Mr. Chairman, this is Senator Hinojosa.
Hey, Senator.
Yeah, it would seem to me that on the public funding issue, that will be a process in itself in finding out what are the limits as to how much taxpayers' money to use to fund the elections. And I think it's a very good suggestion to take some of the big money out of the judicial system campaigns. I think on number two, what do we do with incumbent judges? I think the way to approach it, we may have to come up with a grandfathering phase-in approach with some of the judges that are already elected by the voters. So those are issues that we probably need to massage as we move forward. But I think the suggestions being made in principle and in broad terms are very helpful to get a better understanding where the League of Women Voters stand. So thank you, Ms. Lowery.
Thank you.
Thank you, Senator. Any other questions? Thank you very much, Ms. Lowenberg. We really appreciate your input. It's been very helpful, and hopefully it'll contribute to what we ultimately recommend to the legislature. Thank you so much.
I hope so too, and wish you all well.
Our next presenter is David Jones with the Texas Fair Courts Network. Mr. Jones.
Thank you, and members of the commission. I appreciate the opportunity to have some input into your process. I hope you can hear me all right. I am up on the family farm in Kansas, and we actually have a very good internet connection out here. But so,
well, we can hear you, but your lips are about 4 seconds below your voice.
Uh-oh.
No, go ahead. We can hear you.
All right. I'll do the best I can. I apologize for that. It usually works fairly well. Maybe if I talk more slowly. In any event, my name is Dave Jones. I'm an attorney in Dallas, and I'm also the president of a nonpartisan nonprofit group, a small group called Clean Elections Texas. We work on voting rights and campaign finance reform issues. I'm here not just speaking for myself, but also, or for Clean Elections Texas. I'm here on behalf of the entire Texas Fair Courts Network, which is an affiliation of independent nonprofit and nonpartisan good government organizations. It includes Common Cause of Texas, Common Ground of Texas, Public Citizen of Texas, and as you heard from Julie, the League of Women Voters of Texas. Our group, all of these groups together and separately, have worked on issues of judicial selection for many years through the many different times that there have been legislative study committees in previous sessions and interims on this issue. Our biggest concerns in those years and currently about our Texas system of partisan election of judges have been essentially the same. It's the undue influence that partisanship and campaign dollars has on our judiciary and can have an impact on through the elected system on the qualifications of judges who are actually selected. That is not to say that we all do not believe that the level of fairness and impartiality and qualifications of the overwhelming majority of judges in Texas is exceptional. But we would think it would be irresponsible to ignore the occasions and some of the systemic problems that sometimes show that our system needs to be strengthened. We believe Texans deserve a fair, impartial, and accountable judiciary, beholden only to the rule of law and not money interests, and a judiciary composed of qualified judges. Like I say, our biggest concern with the current system is the increasing threat of large amounts of money being spent on the politics of judicial campaigns. We're concerned about the burden on judicial candidates that having to run for office in an elected system to get enough financial support to run their judicial campaigns. We're concerned about the undue influence large donors may have directly on the fairness and impartiality of judges. And then we're also concerned about the risk alone of undue influence, including the appearance of undue influence on Texans' faith in the rule of law. And finally, we have to mention that we're concerned about the increasing amount of unregulated outside spending on campaigns that we've seen, some here in Texas and in other states, where money is spent on judicial races, not directly donated to the candidates themselves, but through so-called outside groups that are called sometimes dark money groups, where the identity of the donors to those groups is unknown. That's a particular problem that we are concerned about. We know that this is a sophisticated commission, and you all are familiar with a lot of these statistics, but the amount of money involved in judicial campaigns is increasing. And there was a study by the Brennan Center in January of 2017. They concluded that over a third of all the elected judges in the United States had run in at least $1 million election. And then as far as outside spenders and these dark money groups, they found also that 54% of the donors to these outside groups are completely undisclosed. and that leaves the voters uninformed about who is seeking to shape our state courts. So in short, that's why we're here. And we appreciate the opportunity to be heard. We have several recommendations about improvements that could be made in our Texas system to counter some of these problems that we see. We acknowledge that none of these solutions or proposals is perfect. More importantly, for many of them, the devil is in the details of these proposals and how they are actually implemented. If some of them are implemented in ways that are incomplete or in ways that are not fair and balanced, they could result in a system of judicial selection that is much worse than our current system. We have. So we polled our members of the Fair Courts Network and found out what they felt were their preferred recommendations in an attempt to sort of prioritize our proposals. We thought that would be helpful to the commission. Importantly, though, all of our proposed improvements could be implemented independently. Several of them are such that they could be implemented on their own. And could be still meaningful reforms if the commission decided to do something in a way that was more limited in the way of reform. Our broad overall reform that the groups mostly support, as you actually heard Julie mention earlier, that is a merit selection system relying on an independent judicial nominating committee or committees, providing a limited number of nominees to the governor, who would then make the final decision. We think that's the most efficient way to do it. We sort of call that the O'Connor/Missouri plan, after Justice Sandra Day O'Connor, who's had a lot of influence in this area, and the Missouri plan that's been around for many, many years. However, one thing we want to make sure is clear about our support for a merit system. It is absolutely essential that to the fairness and the acceptability of such a plan, that the committees are truly independent and that they are fairly selected. Any nominating committee that has to be selected in a fair and truly independent manner. If the best practices are not followed and mandated in law about how the committees are constituted, then such a merit system could be much worse than our current system. If, for instance, committees are constituted in a way that permits excessive partisanship, or in a way that gives too much discretion to the governor or any other final decision maker, then it could open the door to cronyism and partisanship, and we would not endorse such a merit selection plan. And in fact, we would probably actively and as loudly as we could oppose it. So I know there were some questions for Julie about how such committees or nominating commissions could be set up and who would appoint them. There's a number of issues that go into that. My written testimony that I submitted, thanks to Joanne Richards with our group, who's really done a lot of work on all of this, includes a couple of appendices that has a couple of articles cited from the Brennan Center and from the Institute for the Advancement of the American Legal System on best practices for how to set up are you hearing me okay? How to set up such commissions. We would recommend those to you. We don't have a specific consensus on exactly what parts of those recommendations should be accepted, but there are some of them that we think are absolutely important. We think that the power to appoint commissioners should be diffuse, that there shouldn't be any single source having majority control. It should involve elected officials across all branches of the government. There should be an open application process. allowing members of the public to serve as commissioners. And the commission should have bipartisan membership and even include independents. We would encourage diversity among the commissioners, require appointing authorities to consider gender, race, demographic characteristics, small town, large town, reserve slots for underrepresented legal specialties, and reserve slots for non-lawyers, of course. Those are all taken basically from the best practices that the Brennan Center and the IALS has set out. So we're not firm on absolutely all of that, but that would be our recommendation. The plan, as we see it, should apply to all appointments, whether it's the initial appointment, if there's a retirement, on death, or non-retention for whatever reason. Finally, what we include in our list of things we would prefer is a component we call a judicial performance evaluation committee, which would be actually either a new entity set up or could perhaps be done through the Texas Commission on Judicial Conduct if it was jurisdiction was increased. It would not necessarily be dispositive, but it would be a way under any system to have a general evaluation of judges, not about judging their decisions case by case, but to evaluate their performance in a more general way, just as to characteristics that apply to good judging, such as temperament, knowledge, and so forth. So those are, that's an additional component, and there are recommendations in the appendix. I think it's appendix number 2 to my written testimony that includes recommendations about that from the IAALS and from the Brennan Center, I think, as well. So that's our overall big picture favored proposal, but we also understand that there are other things to consider, and we live in an elected system, and one of the things that we feel like in one of our additional recommendations is that under any elected system that the voters be provided with better information. There are a number of states that provide pamphlets to registered voters that give judicial candidates an opportunity to set forth all their qualifications and give them an opportunity to describe themselves in more detail so voters have the opportunity to be better informed. We support that, and that's been, I believe, a big proposal by the League of Women Voters for many years as well. The Secretary of State, we would envision, usually distributes those types of pamphlets to all voters for whatever jurisdiction it might be. So that is another key part of what we're recommending, and think it's extremely important. Another part, as far as we don't have a specific recommendation listed about this, but if we continue to have elected judges, this issue of dark money is key, and we think that there should be better disclosure laws requiring the disclosure of the actual donors to these independent spending groups. The way it is right now, these groups spend money, but they donate to a lot of times to groups that have very sort of vague patriotic names like Americans for Justice or whatever. I just made that up, but it's we need to know who's behind it, and the candidates need to know who's behind it.
Mr. Jones, I think the time is about up, and we're on a tight schedule. So,
yes, sir. A couple more, and I'll be real quick about it, actually, though, although I do believe they're real important, and maybe I can just answer questions about them. The other thing we do support is an increase in the minimum qualifications. We think there should be board certification or at least a minimum requirements of experience, including first trial experience or first lead counsel in an appellate situation experience requirements. So the increase in minimum qualifications is another important recommendation we have. And then recusal reform is the final one that we see as really important. One of the things that has happened is the recusal has changed. The United States Supreme Court has decided several cases. I mean, it started with the Caperton case, but it's gone forward to include some more recent cases, Williams versus Pennsylvania and Rippo versus Baker, that make the Texas system not exactly compliant, in our opinion. Those cases, especially Rippo versus Baker in 2017, made it clear that the focus is not just on actual prejudice of a judge. Sorry, that's my timer. I'm trying to set it up. My time is up. I apologize. But those cases need to be evaluated in terms of what Texas has done. The law has not changed. Our focus is still on actual prejudice, and Ripple versus Baker makes it clear that it is a focus on the risk of actual prejudice or the probability of it. And they actually vacated a Nevada court that followed that actual prejudice standard. So I'm sorry, my time is up.
If we were in the Supreme Court, the red light would now come on. First of all, I want to thank you for taking the time for your submission.
Yes, sir. I understand.
And also your presentation today. I'm sure that there are going to be a lot of questions, and I have one I want to start with. And this is a follow-up on the question I asked to Ms. Lowenberg. I understand the commission you're talking about, and I understand the best practices and the criteria that would be used to select those people, but I'm still not clear who would actually select the members of the commission, and wouldn't politics necessarily enter into that to some extent?
Well, the idea is, and like I say, we don't have specific recommendations. There's a number of ways that it's done that we think it's very effective, and it includes a lot. There's a lot of different ways that it's done, but it's important to include people who are involved, elected representatives, for instance, that are bipartisan, people across different levels of the government. It might include former judges, members of the state bar that would be involved in appointing, so that there is no one group that dominates the appointment process. I think that's just incredibly important.
Okay. Questions by other members of the commission?
Judge Jameson has her hand up.
Okay.
Yes, once again, thank you so much, Mr. Jones, for your testimony. You brought up a couple of new issues that I'm not sure we've discussed and may very well be outside of what the legislature has asked us to look at. So I'm going to defer my questions on those. But one thing, you mentioned that your group might actively work against a proposal that did certain things, but you're not particularly specific about that, except I think I heard too much discretion to the governor. And then as we talked about what you wanted in there were choices, but nothing specific. So I guess I want you to hone in on what mistakes this commission could make that would lead your group to advocate against a proposal we came up with.
Thank you for that very specific question. I'm not sure I can give you a specific answer. I think that, like I said, the devil's in the details, and what we're trying to avoid is giving too much discretion to any one political party, any one specific political official, including the governor. I mean, maybe especially the governor. And that's why the way these commissions are set up, is very key, and it has to be diverse. I mean, it has to include, like I say, bipartisan representatives and be constituted in a way that there's no specific dominance by any one group. And I don't know if that's a complete answer to your question or not. But.
Well, the difficulty is sometimes too much discretion is in the eye of the beholder, I think. And I believe one of your suggestions was the commission would give the governor more than one choice. Isn't that inherently discretion for the governor to pick one or more of those choices?
That's a very good point, but it really would be only a limited number. And in a lot of states where this is done, the governor is presented with 3 different nominees, for instance, and that have all been selected and approved by the commission, and then has discretion in it to appoint a person, one of those nominees, and that provides some discretion, absolutely. And it gives, but it also gives that power to an elected official finally, which is one of the complaints about these kinds of commissions, is that it deprives elected representatives from making that decision, or the voters, of course. And it is a way to add some more power, I guess, and discretion is really say it, I guess, to an elected official.
Well, I won't belabor this because there are other members of the commission who might want to talk, but again, I want to ask, what is your pinchiest pinch point on this? What is the thing that your group is most worried about?
Well, I could envision
if a system is set up. What's the biggest goof we could make?
I think that there are a lot of places where we would be a lot of versions of such a system that you could call a merit-based system that is really dominated by politics, and it goes to who's making the selection and whether there's adequate diversity. And I don't want to get pinned down on the specifics, because I just don't think that it would depend on the system. I think there are many versions that we would disagree with, though, if it didn't have sufficient diversity, didn't have sufficient broad-based nominees to the commission, and the manner in which the members of the commission is selected did not provide for real bipartisanship or nonpartisanship in who the judges are that are actually selected.
All right, any other members of the commission? Question?
I have a question. Would you distinguish between appellate courts for the system that you are recommending, or do you think that this ought to be a system for all judges, top to bottom, no matter the geographic region or population? What's your thoughts on that?
Chief Justice Jefferson, I think that it would. We don't have an absolute view on that. That's a consensus of all our groups, but I think there is merit, and we all have discussed the fact in having more than one commission, or having commissions that are at different levels. For instance, that when you're talking about if either, for one thing, there could be a system where the commission only addresses appellate court judges and not district court judges, and that district court judges would still be elected. Or even if you had a system where both appellate and local judges were appointed, that there might be more than one commission, and a commission that is maybe slightly constituted in a different way, so that in small towns and in rural areas, and when you get to the district court level or the county level, there's those specific areas and knowledge of what it takes to be a good judge in those areas.
Okay, thank you.
Does that answer your question?
Yeah, it does. Thank you.
All right, any other questions by members of the commission?
I have one.
Yeah, go ahead.
Dave, I'm assuming you've studied other states' plans. Is there any particular state that you've looked at that whose plan that you like, or like more than others?
I hesitate to say that. There are a number of states that have some good plans. There's a real mix. I guess the answer to your question, to be really direct, is no. I don't have a specific state that I could point you to. It's the qualities of the commission that are more important to us. And the recommendations that are made by the IAALS and by the Brennan Center and the best practices that we've listed in the appendices to this testimony, I think are a good guide of the overall of what we need. And it's taken from several different states. It's something that's not any particular state.
Okay. Any other questions? But I have one last question. Assuming that we continue with our elective system, how do we educate voters when there are in excess of 50 judges that are on a ballot at any given time? How do we do that? Do you have any thoughts as to how we educate I mean, it's important to vote, but it's also important to have an informed vote. So how do we educate our voters about who the good judges are, if you will, and who the judges are that maybe aren't doing what they should do in terms of their responsibilities? How do we do that?
Well, we have a specific recommendation about sending out some more detailed pamphlets that could be provided to all voters, so that if they choose to take the time to try to decide between different judges in an election, that they could at least have access to that information. That the other component and the idea of a judicial performance evaluation commission is something that I think at least I wasn't that familiar with, and we haven't really talked about a lot. But there can be systems where, at least for existing judges, or maybe even for people who are running for office, for candidates, that at least an advisory set of recommendations from such a commission could be provided to voters, and that would give them some information. It might have the ability to at least exclude people who are just blatantly not of the right temperament or whatever to be good judges.
Okay. Thank you. I really appreciate your presentation, Dave. It's been very, very helpful. You hit on a lot of different issues, which we'll certainly take under advisement, and at some point we'll be preparing a list of recommendations. So you'll get an opportunity to review what we've done. Thank you so much for appearing.
Thank you very
much. Okay. All right. I think our next presenter is Jeff Mosley, who's Chief Executive Officer of the Texas Association of Business. Mr. Mosley.
Good morning, Chairman Beck and members of the commission. Thank you for this chance to present, and thank you for what you're doing. I applaud the commission for giving time to meet this mandate and to evaluate our current system of judicial selection and to make recommendations as necessary. For nearly 100 years, the Texas Association of Business has really been pleased to be the voice of business. We were created in 1922, just ahead of the Depression in San Antonio. So we're excited about coming up on our 100-year birthday, and we have members that employ hundreds of thousands of Texans, and we represent about $8 billion annually to the Texas economy through our member companies. And we are the state chamber of commerce with friends all over the state, about 200 chambers that are members of TAB. And so that's why we're so pleased that the commission is convening to take a look at this important question, because, you know, for our members and for our partners, we know that it's so critical for the courtrooms of our state to remain halls of justice, where we know that disputes can be resolved based solely on the facts of law. We've even established here at TAB a litigation center, because more and more our members are seeing the value of not only pursuing pro-business policy through legislation, but from time to time, it's very important for us to be in the courtroom, either through an amicus brief or actually engaged maybe through coalitions pursuing, litigation. So we recognize the fact that there is a direct tie to the business climate of the state and having competent, fair-minded judges. And so that's why we're very pleased to, support the efforts that you and the commission are bringing to find the best system available. And clearly, as we continue to grow to become the largest state in America, there's going to be more and more demand for capacity and more demand for services. So finding that best fit for the judicial officers to come and to serve in those courtrooms is really going to have a very important and direct impact on the business climate. So I really was just checking in to say thank you so much for what you're doing. And we're pleased to be a resource as you go forward. And that really is kind of the basis of my statement. Be pleased to try to respond, Chairman and members, to any questions or comments.
Okay, well, thank you very much, Mr. Mosley. And I will ask just a quick question. Does the Texas Association of Business have any view with respect to our current system as opposed to some other system, like an appointive type system?
Yeah, I think, we're just pleased to be a part of the dialogue just to see how there could be any possible updating or refreshing. A state as vast as Texas, a state that has clearly highly urban areas and very distinctive rural areas. We know that Texas has really enjoyed operating efficiently off of, basically two sets of laws. And those are called bracket bills. And depending on populations, we look at things differently to address certain issues. So perhaps there's some opportunities as you go forward to look at the very important, the very good things about Texas and its diversity. And maybe the system that you're looking at, there would be remedies that work best in urban areas that might not work as well in rural areas. There might even be opportunities to look, as Justice Wallace asked earlier, at the level of the jurisdiction of that court. Most all of the disputes are handled in the People's Court, the Justice Court. So maybe there would be a recommendation the commission would make related to the lower courts rather than what would work for the higher courts. We don't have a specific recommendation, but we're pleased to be a resource to you and the members of the commission.
Okay, thank you, Mr. Mosley. Questions by members of the commission?
Mr. Mosley, this is Wallace Jefferson again. In many states, or many businesses that come into Texas from out of state have expressed their dissatisfaction with the system in which the lawyers or their clients are making contributions in the very case under consideration by the judge. Do you have a similar distaste for either the influence of money in that respect or the appearance that that decisions are made based on considerations that are outside the merits?
Justice Wallace, I have a confession to make that I served as a judicial officer for more than a decade in Denton County, and I actually started out as a justice of the peace for 4 years, and then I was a county judge. I'm not an attorney, but I did have to run as a judicial officer and seek election. And it's pretty interesting whenever you abide by the Judicial Ethics Commission, you really can make no promises as a candidate for a judicial office, except to basically use a platitude, justice delayed is justice denied. And the more often that you force a judicial candidate to go back to an election, then you are asking that candidate to reach out and find the means to pay for getting that message out. And so, perhaps one of the things that you would consider is has already been discussed, is having longer terms of office where the election cycle isn't as important to that judicial officer in seeking reelection, and perhaps that it would be one of the remedies that would be useful.
Great, thank you.
All right, any other questions by the members of the commission?
Yeah.
Okay.
Hey, I'm sorry. Hi, Jeff. Congratulations on, as always, the good job that you do. And we've been friends for a long time and appreciate your appearance. You talk about, and we appreciate your offer for being, of providing a resource. I wonder if you could drill down on that a little bit and maybe make some suggestions to us or give us a little bit more insight into when would be the appropriate time to contact you and what kind of resources you might have in mind.
Hi, Lynn. Good to see you. Well, we have a group of members that clearly have a very well trained division of lawyers, and that group meets regularly. I mentioned earlier that we have a litigation center, and Jay Rutherford on our board heads that up. And so David Cabrales is a part of that litigation center, but we'd be pleased to direct inquiries to that group of attorneys at the Texas Association of Business and make that a resource to you and to the commission.
All right, any other hands raised?
I've got one raised, Chairman Beck, if I may. Mr. Mosley, thank you. This is Chip Babcock. Do you, following up on that last question and your response, do you have any statistics, information, or data on how much money business, either directly or indirectly, contributes now to the various judicial elections?
I do not have that in my top desk drawer, but we'd be pleased to, perhaps that's a good place for us to begin, being a resource to the commission, is to poll our members and get a sense of what that response would look like.
I think that would be very helpful, Mr. Mosley. Are you willing to do that?
Yeah, I'd be pleased to see if we can find out.
Great. Thank you.
Thank you.
Any other questions? All right, there being none, thank you, Mr. Mosley. We really appreciate your assistance and that of the Texas Association of Business. And it sounds like we'll be having additional contacts in the future. So thank you so much.
Thank you, Chairman Beck. Thank you, commission members. Appreciate your hard work. Thank you.
All right, our next presenter is George Christian on behalf of the Texas Association of Defense Counsel. George.
Thank you, Mr. Chairman, and good morning. Hope everybody can hear me. It's good to see you again. I was on the panel in March, as you recall. And
George, your face looks a little different than the last time.
Yes, I noticed Representative Landgraf's does too. In that brief moment, we're having the same problem with our razors. And I haven't been to a barber in a long time, so this is a homemade haircut. Thank you for inviting the Texas Association of Defense Counsel to present today. As many of you know, TADC is sort of the state association for civil defense trial lawyers. We have more than 2,000 members. They're all over the state. TADC, while there are members of TADC from big firms, TADC is prominently, the great majority of the members are from small and medium-sized firms, in smaller towns and cities across the state and rural areas. So we have a very broad base of practicing lawyers who are very familiar with the problems of the current judiciary and have been involved since the establishment of TADC in the 1960s in various efforts for reform. And remember, this goes back to the Constitutional Convention in the early 70s, in which the proposed Constitution that was rejected ultimately by the voters did contain a merit selection plan. And I think we kind of forget that that was part of that document. It wasn't that controversial at the time. There were other things that killed that effort. Interestingly, not really the judicial selection part. So, you know, this has happened before, and there have been a number of efforts since. As you all know, TDC has always consistently supported some form of appoint-retain system. Whether it was a closer to the Missouri plan that was discussed earlier, supported Senator Duncan's efforts to go to an appoint-retain plan. As y'all remember, Tom Luce chaired a commission in the late 90s. I served on that commission, which recommended an appoint-retain plan. TDC supported that plan. TDC supported Representative Landgraf's bill last session, and TDC would support a bill that very strongly support a bill that embodied the TLR TCJL plan that was laid out at the last meeting of the commission. That plan, we think, is got a lot of very attractive features to it. You know, obviously, no plan is perfect. No plan will remove all of the politics from the system. So what you do is you try to make as many people accountable in whatever system you come up with so that nobody dominates, you know, the selection process. And we think that plan does a really good job at that. It spreads responsibility for getting qualified judges on the bench. It enhances qualifications for judges, which we think is a really important aspect of whatever you all end up recommending and the legislature considers. And it gives you more ways to remove judges and more specific reasons to remove judges. And we think that plan, more than any other plan we've seen in the last 40 years, really does, I think, address a lot of the systemic problems besides the election process. I mean, we talk about how do we elect judges. That's certainly the key political issue for sure. But, you know, that the TLR TCJL plan really does a good job kind of taking up some of these other important issues, a lot of which Dave talked about. And so we think that is a great basis for moving forward and getting a plan before the legislature that, you know, can get serious consideration. And, you know, obviously, there are a lot of different views about, do we elect judges in partisan elections? Do we do it in nonpartisan elections? Or do we have some kind of appoint-retain system like TADC supports? And I would just point out that, you know, ultimately, however the judge gets there onto the bench, we would prefer it in kind of a merit-based appoint system. But however that person gets there, that judge is a public servant, and the courts belong to the people of Texas. They really don't, I mean, as much as, you know, my grandfather was a judge on the Court of Criminal Appeals for 14 years. And, you know, I think the way he looked at his job, from what I understand from my dad, was he was a public servant, and the courts belong to the people, right? They don't belong really to the lawyers. They don't belong to the judges themselves. And if you walk into a court in this state, whether it's in Amarillo or Lufkin or Brownsville or wherever you are, you're entitled to the same justice that somebody gets, right, in a court somewhere else, and somebody who may have given a lot of money to a judicial candidate or has a close political relationship with the candidate. You deserve the same justice, and you deserve the same impartiality. And, you know, I think we all know the perception and sometimes the reality in our courts is that, you know, some people are more impartial than others. And, you know, ultimately that's what the clients of the, you know, lawyers that I'm speaking on behalf of today, that's what they want. And they do worry if judges have gotten contributions from counsel on the other side, or from, you know, the party on the other side. they do ask that question. They do worry about it. And it's a hard question. I think Chairman Beck, you alluded to this. As I recall in one of your meetings that you get asked that question. That's a very uncomfortable conversation for a lawyer to have, because what the client wants to hear is a fair evaluation of your case. And do you have a legitimate defense? Do you have a legitimate claim? Well, you tell them that, and they go, well, does it matter? Because am I going to get a fair shake? That's the question that we should have no doubt about in answering for our clients, for ourselves, for our families. And to us, I think, moving towards something like the TLR TCGL plan, I think would give, our people a lot more confidence that they can answer that question with confidence. Yes, you will get a fair shake. But again, right, devil is in the details, but I think that plan is sufficiently detailed to at least give us a really good starting place. And certainly, next session, we're going to be supportive of whatever y'all come up with. Hopefully it'll look like that plan, but whatever you do, I think, you can count on TEDC to support it enthusiastically and to use our thousands of members around the state to, advocate for it with their own elected officials, their judges, their state representatives, their senators. And you can count on us. We're in all the way. So thank you for having me. Thank you for this opportunity. And thank you so much for the work you're doing and under really difficult circumstances. I don't know what's going to happen tomorrow in the world, but the fact that y'all are still, doing this work is really, it's really inspiring and gives me a lot of faith in our system of government. And, I appreciate it. And so do our members.
Thank you, Mr. Christian. I think we all agree that the rule of law is critical to our democracy. And I think we also would probably agree that the integrity of our system is paramount. If our people lose a belief in the integrity of our system, then there are very serious adverse consequences. So I think we can kind of start with that. Yeah. So members of the commission, questions, please.
I have a question, if I may.
Sure.
Senator Hinojosa.
Go ahead.
How are you, George?
I'm very well, Senator. It's good to see you.
I guess what you were saying that we're all equal, but some more equal than others.
Well, I've said more impartial.
Okay.
not more equal. I think. I think the perception is, and certainly that I hear from members is, some courts are tough, depending on who your client is or who's in there. So that's been a problem for a long time, and I don't think you'll ever totally eliminate that potential for a perception like that. But I do think it's it's one of the underlying problems we have to address.
Well, I think quite frankly that we have judges, some that are very conservative, some are liberal, if you will.
Yes.
But the focus ought to be on the campaign contributions. That is what makes attorneys concerned about getting a fair shake in the court when your opposing counsel is a big contributor.
Yes.
It makes quite a difference.
Yes, sir, it does. And I mean, we supported, obviously, in 1995, the Judicial Campaign Fairness Act that Senator Ellis, as you recall, carried. Lieutenant Governor Bullock, helped get that done. It's a good start. I mean, we did, I think, make some progress in at least trying to get a handle on contributions by attorneys, to limit law firm contributions. I think transparency is an issue. I don't think anyone saw the Citizens United case coming. And that, to me, has really changed the dynamics of political campaigns generally, and the potential for all of these independent expenditure groups getting into judicial races is very frightening to me and to our members.
One last question: would you, I guess, have any suggestions or support public financing or funding of our judicial campaigns?
I'm not asked. Our group, can't think, has taken a position on that. But I suspect they would be very open to that.
Okay. Thank you, George.
Thank you, Senator.
Yeah, to follow up on Senator Hinojos's question, which I thought was an excellent one. If we have an election system, a judge has to raise funds to get his or her message out. How do they do that? They go to the people that they know most, who are the users of the court system, which are lawyers. And I will tell you, lawyers are not particularly happy about getting hit up for contributions in the Democratic primary and Republican primary, and then in the general elections, or there's runoff in those elections. But how does a judge raise sufficient funds to get his or her message out if you don't have public funding?
Well, I think that's a great question. And I would say there's almost no way that most judges can raise sufficient funds to do that effectively in today's environment. As you know, we don't run campaigns the way we did 30 years ago, where you had a few TV stations and, big radio stations, and you could reach people, in a fairly sort of, fairly limited media. It doesn't exist because of all of the ways now that political campaigns have to try to get through the clutter. And I just don't see how judges can possibly do that. And I know, even our Supreme Court justices who are, you raise $1 or $2 million or $3 million, or that's a drop in the bucket when you're running statewide in Texas. And if you're running in Harris County and you have 50 judges on the ballot, how in the world are you going to distinguish yourself? I think the appoint retain system would help that quite a bit, I believe, because, it would remove a lot of people from the partisan ballot. And I didn't mention, now that we don't have straight party voting, that used to be kind of the proxy for, a judge's judicial philosophy was which political party they run from. And, a lot of people pulled that lever and just said, well, I'm all one way or the other way. And now it's even more important for people to know who the candidates are, because they have to go through that ballot one by one. And I don't know how that's going to come out. And I would prefer to get these judges off the partisan ballot, and, groups like TCJL and TDC, we have a texasjudges.org website where we put up, we send every judicial candidate a questionnaire. They fill it out. It's got their experience, their qualifications, their education, their, a statement about what their philosophy is. And we put all of that on that website so people can compare these candidates, sort of apples to apples. And I just think that's what we got to have is, the more of that sort of resource that we can bring to bear, which we're trying to do, I think the better results we're going to get in whatever system we have. Okay. That will improve the election system too, is dissemination of better information that's accessible and usable. It's a format that you can actually use it. That's what we're trying to do at texasjudges.org.
Okay. Thank you. Any other questions by members of the commission?
Judge James and Chief Justice Jefferson have their hands raised.
I'll go first if you don't mind, Chief. Hello, Mr. Christian. Good to see you.
Judge, good to see you.
I understand that your organization anticipates supporting whatever this commission comes up with, if anything. if it is different from keeping the status quo. I understand that your preference would be to follow fairly closely the proposal that was that we discussed at a prior meeting, TLR and some other groups had put together. But I don't know if you heard Mr. Jones's testimony earlier and my annoying questions to him. I'm just trying to find out where are the areas of discomfort for your group in terms of designing a system. I know that you've looked at other state models. Sometimes they give the governor more discretion, which Mr. Jones's group is a little nervous, I think, about how much discretion the governor would have to select from what a commission puts forward. And so I'm trying to identify from your perspective, where do you get, where does your group get nervous in terms of looking at a commission that would suggest nominees for a governor to suggest, or some other similar system?
I think where we would get the most heartburn in, an appoint retain system would be, just making sure that the commission, whether it was a, pre-nomination commission that made, recommendations to the governor, or a post-appointment vetting commission, as the TLR TCGL plan suggests, or some other format, is that it would be broad-based enough and wouldn't be, and would be it would be bipartisan, or it would be right down the middle. That's kind of what we want. We just don't want it weighted to one side in terms of party affiliation, or to have too many of kind of one sort of category on, or too many. It's got to have lay people. It's got to have judges. It's got to have attorneys from every practice area should be involved, and it's not just civil lawyers. And so we would really be, I think, if it were too one-sided or
and
too
is that
narrowly based.
And so is that something that one knows when one sees the composition of the commission, or is that something that one needs to have baked into the enabling legislation?
I think it needs to be in the enabling legislation so that it's consistent and it doesn't change depending on, who's in office at that moment.
Thank you. Thanks for your thoughtfulness.
Thank you.
Commissioners, any additional questions of Mr. Christian?
Yes, I have one. Hi, George. How are you?
Hi, Judge. How are you?
Doing great. Just given the history of the contentiousness in prior battles for the Supreme Court and other courts.
Yes, sir.
We would be thrilled to see any kind of consensus reached among the people who are testifying before us today. So my question is, do you think it would be possible for you and the Trial Lawyers Association to agree on most or all aspects of an appointment retention system?
I certainly hope so. And I know, lawyers in our group and lawyers in TTLA, have different levels of, opinion about this issue, but I think it's entirely possible that that can happen. And, certainly we're going to work with TTLA that, I think that's important for all of the profession to come together. So yes, sir, I do think that.
I think that would be very helpful to this commission's consideration of potential reforms.
Yes, sir, I agree.
All right, thank you, Chief Justice Jefferson. And any other questions by members of the commission? Mr. Christian, thank you and the TADC for your input. We really appreciate it.
Our pleasure. Look forward to working with you.
Okay, bye-bye. All right, our next presenter is Robbie Alden with the Texas ABOTA, Texas American Board of Trial Advocates Group. Robbie, you're on.
Thank you, Chairman. I hope you can all hear me okay.
We can.
Good. As Chairman Beck said, my name is Robbie Alden, and I'm testifying on behalf of Texas ABOTA, which is the regional chapter of the American Board of Trial Advocates. It's comprised of 15 chapters around the state of Texas. For those of you that don't know, ABOTA is a national association of experienced trial lawyers and judges dedicated to the preservation and promotion of the civil jury trial right provided by the 7th Amendment to the U.S. Constitution and the Texas Constitution. There are 1,400 lawyers and judges in Texas who are ABOTA members. It's an invitation-only organization where members must have significant trial experience and a history of practicing law with civility and integrity. Our membership includes both plaintiff and defense lawyers, most of whom are members of either TADC or TTLA, who are also organizations testifying today. And our membership includes esteemed members of this committee, David Beck and Chip Babcock. We greatly appreciate being invited to participate in this meeting. We are committed to supporting your efforts and the efforts of the legislature anytime you seek to improve the quality of the judicial system in Texas. When we received Chairman Beck's invitation to testify today, I conferred with the members of the Texabota Executive Committee, which includes past presidents and judges, former judges, other members who were on this conference call, such as Jennifer Doan, who's the chair of the litigation section for the state bar. They are leaders of the trial lawyer organizations and activities in Texas. And I don't know whether you'd be surprised by this or not, but after conferring with them, I'm not sure that we can come up with many really concrete recommendations for this committee. You're biting off a huge challenge with your work. We do think that one of the most important changes that could be made would be to increase the qualification requirements for judges. Ideally, there should be some system for verifying those candidates' qualifications. Perhaps a nonpartisan commission might be created to verify or certify candidates' qualifications before they are allowed to actually run for office. While we agree that improvements are needed in the way we select judges, we think it's unlikely that the Texas Constitution could be amended to allow an appointment system. We frankly don't think that the voters would approve the amendment. And based on our experience with appointed judges in federal court, our organization, I don't think, can say that appointment would necessarily be an improvement. We have seen all too often over the last decade that partisan politics have a detrimental effect on not just the appointments, but the public's opinions of the judicial system itself. If this committee decides to recommend some appointment system and a constitutional amendment that would be required, we believe it is vitally important that the commission be balanced and preferably nonpartisan. Any members of the commission should have significant appellate and litigation experience. Historically, the ABA played an important role in vetting candidates for appointment at the federal level, although lately their recommendations have too often been ignored in favor of partisan politics. Perhaps there's a similar organization that could be involved in vetting candidates for appointment in Texas. It would also be important that a commission be structured to ensure that diversity is involved not only in the commission, but also with the judicial candidates. Nonpartisan elections may be an improvement, but it's unrealistic to think that nonpartisan elections will completely take partisan politics out of the system. Partisan money will play a role. In the larger counties, there are more judicial candidates than other county elected officials, and judges attract higher contributions, mainly from lawyers, than the other candidates, non-judicial candidates. We do agree that better disclosure laws for campaign contributions would be an improvement. One of our board members even suggested perhaps that more information be put on the ballot about the judges so that you can see at least some of their qualifications. I don't know whether that's realistic or not, but it would help. Too often, I think members of the public go into the ballot box not really knowing who the people are that are running for judges. Too often, I think they vote depending upon whether they have an R or a D after their name. And frankly, whether you're a Republican or a Democrat doesn't necessarily qualify you to be a judge. I want to end by commenting about something that Mr. Christian mentioned, the importance of parties having fair and impartial judges. The beauty of the jury trial system is that the judges of the facts are actually chosen by the parties in the case through a process of jury selection that is balanced and impartial. And I hope that the members of the legislature who are concerned enough about the judicial selection system to vote in favor of this committee will realize how important our constitutional jury system and jury selection is to fair and impartial resolution of disputes whenever anyone suggests legislation that would undermine or diminish that right. Thank you, Chairman.
Thank you very much, Mr. Alden. I'm going to go ahead and begin with a question. I want to drill down a little bit more on the concept of a commission. And I think you're absolutely right. You're not going to take politics out of the selection of that commission. I mean, human nature is what it is. But do you have any specific ideas, or does the Texas ABOTA group have any ideas about specifically how the members of that commission would be selected, assuming we went to that type of an approach? In other words, who would approach? For example, if the governor approaches, well, you're not going to get politics out of it. If the legislature appoints, you're not going to get politics out of it. So, I mean, do you have any specific suggestions as to how those members of the commission would be selected?
Well, I think honestly, to eliminate the concerns about politics and partisan politics and bias, whatever system gets created will probably be the first time that system's been used for any committee or commission in the state of Texas. I agree with you that if it's simply left up to the appointment of the governor with the perhaps approval of the legislature, you run the risk of politics being involved too much. And I honestly, David, I don't know that I've got an answer. I don't know whether, the involvement of the state bar, the involvement of the Texas Supreme Court. I mean, there are obviously a lot of people that are very qualified and very concerned about the quality of the judges in this state who might be involved in making those commission selections that could be involved, but it would definitely be a different system than what we've got.
Okay. All right, thank you. Members of the commission, questions?
I've got one, if that's okay.
Go ahead, Chip. Go ahead.
Hey, Robbie, how you doing? Thanks for coming today. Do you think that the money that is in the system now, the selection of judges now, is a bad thing? Is it evil? And if so, how do you think we change that?
Most of the judges that I know personally hate running for election. They hate asking for money. They hate having to go out and raise the money. I know lawyers are tired of being hit up every 2 years, to contribute. So money, there are a lot of negative things about money being involved. Honestly, I have not met many judges who I feel like are improperly influenced by money. I do agree with some of the suggestions that there ought to be better disclosure laws. I don't know whether, I don't know how you could come up with, you've got First Amendment concerns, obviously, so I don't think you can take the money out of it. And I don't know whether you could enact any kind of rule that required money to be nonpartisan that would ever stand up to scrutiny, First Amendment scrutiny. But it'd be nice for you to be able to limit it somehow. I think all the judges that have to run for re-election would appreciate that.
Yeah, I agree with you that I've never seen money influence a judge's decision or how she handles the case. But do you agree or not, or disagree, that there is a public perception, a reasonable public perception, that when firm X gives a lot of money to a judge and the other firm doesn't, the perception is that the judge is going to favor firm X?
Oh, absolutely. And, some of the people on this call may be familiar with the situation that arose in West Virginia a few years ago that was pretty egregious and 60 Minutes wrote about. And I think certainly there is that danger in the public perception.
Is it a serious problem, the public perception?
You know, and the lay people that I talk to, I think most lay people do believe that judges will be improperly influenced by big contributors. I think the lay people are concerned about it. I haven't met many lawyers that have that concern, but I have clients that walk into my office every week who express that sort of attitude.
Yeah. Thanks very much. I appreciate it.
Thanks for the work you're doing.
Any other questions? Megan?
Chairman, this is Representative Minhadis. Hi, Robbie. How are you?
Good. How are you?
I'm good. You know, you talked about, I appreciate the fact that you talked about how critical qualifications are in this area. And I also agree with you. I think qualifications is something that as a commission, we need to spend a lot of time on. I'm an attorney as well, and there have been circumstances where some judges in Bexar County had only practiced for 5 years, but they did well on the bench. They had a fast learning curve, but there are others that didn't do well. What are some of the recommendations you have in terms of qualifications? I know there's been mention of maybe practicing for a minimum of 10 years. Do you have any thoughts, especially on maybe how many cases an attorney needs to have tried to verdict in order to qualify to run for office?
You know, I think we're probably all familiar with the recent statewide elections for the courts of appeal, where there was basically people got elected based upon party affiliation. And there were some highly qualified judges that were voted out of office, and some judges that came into office that maybe didn't have nearly that level of qualification. So, you know, I think it's a very legitimate concern. I'm not sure that a bright line rule of number of years is the best answer. It certainly is one rule that might be adopted. It would be nice if there's some screening process where, you know, to become board certified, for example, and I'm board certified in civil trial law and personal injury trial law, and it's a pretty rigorous process you go through to get board certified as an attorney. I don't know that you need to adopt the same level of scrutiny of judges, but there at least ought to be some process where some independent group can review the qualifications of the person. They may not have practiced 10 years, but they may have 20 jury trials under their belt. So they may be highly qualified. Obviously, I think if you're going to sit on the trial bench, you ought to have had experience trying cases as a lawyer. I think it would be nice if you're going to sit on the appellate bench, you've had experience actually handling appeals.
Thank you.
Thank you, Representative Minhadis. Any other members of the commission have a question?
Well, I'm sorry to be such a pest today, but thank you for your testimony. A lot of our conversation seems geared towards civil trials and civil judges. And I was wondering whether your conversation with your executive board looked at family law, where there are not as many jury trials, criminal law, even probate law, and gave any thought to what might be helpful in those other areas and judges who handle those cases.
Right. Well, ABOTA, the members of ABOTA are civil trial lawyers. We're not necessarily criminal trial lawyers. So I don't want to speak out of turn or on behalf of any of the criminal attorneys that do handle criminal cases. I am very familiar with the judges, whether it's in federal court or state court, that do handle criminal cases. My understanding from talking to criminal lawyers is they share the same concerns about qualifications for judges. In Travis County, we have judges that hear either civil or criminal. In the smaller counties, you know, they hear both type cases. So the issue of qualifications, I think, whether it's criminal or civil, they all agree with. You know, the family lawyers, most of their cases are decided by the judge, and they don't have jury trials. And so the qualifications of the judge are even more important, I think, for them. But absolutely, I think they're equally concerned about it.
Thank you so much.
Members of the commission, questions? If not, Robbie, thank you very much for your presentation. You've hit upon a lot of very good and critical issues, and we appreciate your input and the input of ABOTA. Thank you so much. All right, our next speaker is Jim Perdue with the Texas Trial Lawyers Association. Mr. Perdue, you're up next.
Thank you, Mr. Chairman. My name is Jim Perdue, Jr. I am the president-elect of the Texas Trial Lawyers Association, which means I will be the president as the legislative session starts in 2021. And I look forward to working with this commission, but even more importantly, the senators and representatives who are part of what will be the legislative process in 2021. I think it probably goes without saying that the session coming up may be one of the most difficult that certainly I have seen since I was a Senate page back in 1988 under Carlton Turner. The state faces a lot of difficult issues. This commission faces one of the most difficult issues as it relates to the justice system that has confounded members of this commission and both judges, lawyers, and the legislature for decades. The Texas Trial Lawyers Association is an association of approximately 2,500 members. We were formed in 1949, and we are committed to equal justice and access to justice for those who have been injured, either businesses or individuals, by the acts of another. We have members from Amarillo to Brownsville, from Beaumont to El Paso. And just as with a state that is diverse enough to have 254 counties, which can look as different as California looks from Maine, our membership reflects the diversity of the state. It will not surprise this commission, in fact, I imagine exists on the commission, that members from Dallas County or Harris County or Travis County perceive issues regarding the system of justice and the system of electing judges perhaps quite differently from somebody from Jim Wells County or Potter County or Longview, Texas. That inherent difficulty that this commission faces actually is reflected in the unique aspect of the question itself. As the committee has already gotten the data, if you look at the 50 states, taking apart the federal system, but when you look to the 50 states and the laboratory of democracy that is represented by our form of government, you find that while there has been a proposition that partisan elections is somehow an outlier, when you get past partisan elections, there is almost no two states that addresses this issue identically. There are 8 states that handle trial court elections through partisan elections, 20 states that handle district court elections through nonpartisan elections. After those 28, the remaining 22 become a question of what nature of combination are you looking at? So the earlier speaker, Mr. Jones, talked about the devil in the details. 7 states do some system of appointment with a retention election. 12 states do some system of either a gubernatorial appointment or actually a legislative appointment or a legislative election. And then you have several states then that have different combinations, that the analysis of nominations at the Court of Appeals or at the Supreme Court level exists with a nominating commission or a commission of another nature that reviews then the nominees from the governor, but then defaults down to nonpartisan elections at the district court. The difficulty in creating a 254 state solution is comparable to the difficulty of having a uniform rule across the states that represents some idea that there is a uniform way of the best way to do this. That difficulty reflects itself, I think, in the membership of TADC that you've heard from. It reflects itself in the membership of Texabota, who you've heard from. It is reflected in the concerns that Mr. Jones made about the devil in the details. So we look forward to working with the senators, the representatives during the session. We look forward to working with this commission, but it confronts a very, very difficult question, because while the proposition, importantly, is on hand about questioning the perception of the delivery of justice, to begin that conversation with the idea that taking away people's rights to vote is a solution begins from a very dangerous place of the conversation, from our membership. And let me couch by saying, I know I expect some questions from my friends and colleagues on the commission. I am here as president-elect of the Texas Trial Lawyers Association, and I'm going to do my dead level best to avoid having my personal opinions about this topic or the solutions to this topic enter my testimony today, because TTLA was invited to be here today, not me as an individual. And the diverse membership of TTLA, just as Mr. Robbie Alden reflected, has a wide variety of views on this. And there is no consensus that would allow, just as with the other people who have testified, a recommendation to this commission on an alternative system than what we have from the status quo. But there have been some really productive things already mentioned, which I think on behalf of the Texas Trial Lawyers Association, I would like to second. The issue of qualifications is fairly before, I think, the commission, and can fairly be put before the legislature in 2021. Currently, a individual need only have practiced law for 4 years to be an appropriate nominee on the ballot for district court. And by the way, as to Judge Jameson's question, which is important, the concerns of the civil trial bar can be very different than the concerns of the criminal trial bar, can be very different than the concerns of the family trial bar. This commission is tasked with a solution that impacts all of those, and those different constituencies likewise can raise the challenge of a single solution across 254 counties that also impacts all 3 systems of justice. Our membership uniquely is on the civil side. I obviously have friends and colleagues who practice family and criminal. Their perceptions of this particular issue can be different. There are members of the minority community who have important voices to add to this commission, especially on the topic of qualifications. Because when the commission begins to study qualifications, which again, I think on behalf of TTLA, we would say we support that analysis. But as Mr. Alden pointed out, when you set a hard line, there is a risk, an inherent risk of cutting off access to service as a jurist to certain constituencies that need to matter and need to have a voice. But certainly 4 years of practice being the sole qualification necessary to qualify for district court is an issue that merits reflection. Is that enough time? We live in an age, as the chairman knows well, it's very difficult for young lawyers to get trial experience, especially as first chairs. Personally, I like the idea of judges who have practiced in trial and have tried cases. Personally, I like the idea of Supreme Court justices who actually practiced law in private practice and handled appeals before getting to the Texas Supreme Court. But those hard lines, if they become an element of legislation, need to be analyzed, because there are people who have served in the past and those that would like to serve in the future who conceivably could be impacted. But I think the issue of qualifications is an extremely important one. And the analysis of the 4-year kind of floor on district court service is definitely something that merits analysis. I think we would support analysis, but like I say, there are constituencies that I think have voices that are very important to that topic that need to be heard. Second, there was a reference to dark money and the prohibition on the increase of dark money to judicial contributions thanks to various federal precedent. TTLA would absolutely join in the effort to address the influence of dark money and a prohibition on outside dark undisclosed money in judicial elections. The confidence in the system is indeed undermined by that type of financial influence. As a corollary to that topic, the disclosure of contributions to judicial campaigns could frankly be made much more robust. There ought to be a system because so much of this conversation seems to center around lawyers who are contributing to the jurist for whom the case is in front of. There ought to be a central clearinghouse that would allow much easier access for that to be identified. And that if there are people who have contributed to a certain jurist, that somehow the state would provide the resource so that the parties, litigants, lawyers would have some means by which identifying those contributions in an easier form. The Texas Election Commission does a yeoman's job, but that is difficult. But it is one that is solved through information technology solutions that can be achieved either with some type of immediate online reporting and a more robust database available. The additional issue then, and I will say this as a point of personal privilege as opposed to of TTLA. I think it's very dangerous to take the assumption that voters lack education or capacity to vote on judicial elections. That proposition seems to be underscored with the idea of separating the issue of money, but there seems to be a continued theme that voters are either overwhelmed by the number of judicial elections on the ballot or underinformed as to the candidates on the ballot for judicial race. I tend to have a little more faith both in my personal choices and in the system of democracy. But to solve that particular issue, rather than throwing out elections as a whole, there have been some solutions proposed, which is better voter information, better information regarding judicial candidates that somehow could be supplemented through this, either the Secretary of State or county clerks. That would allow, again, some flexibility across a difficult 254 solution. But I imagine that the commission would be aware that the voters in Rockport probably have a pretty good idea about who their judicial candidates are and feel pretty informed going into that election. So the idea that the conversation is faced on a ballot that is unique to Harris County, requiring a solution to a state as diverse as ours, again, raises the challenge that the commission faces. And it is a big challenge and one that has been difficult to solve for a long time, which is why the diversity, when the commission looks at how different states do it, leads to kind of the testimony that Justice Heck gave after his report last year, which is, so what is the best solution? And even the Chief Justice is confronted with, I'm not sure. And so on behalf of TTLA, I would say we share that position. I don't know. Justice Jameson has asked some incredibly important questions about pinch points. And they have gone basically to the idea of who appoints the commission, who are the members of the commission, if you had a nominating commission system, and how are they selected. Now, I know Justice Wallace Jefferson has published with Justice Corliss from the Colorado Center and the Brennan Center of Study. There is some good publications regarding the variety of means. And interestingly, this so-called O'Connor system is only kind of modeled out of 4 states. So there are more states that have partisan or nonpartisan elections than the proposed model of best practice represented in O'Connor. system of appointment. But there is, if the question is asked about the necessary diversity, transparency, and constituencies that are reflected in any nominating commission, things that this commission can call upon. Whether it be as a trial lawyer, a defense lawyer, a party, any commission needs to reflect the diversity of the state, the diversity of interest as hands. One thing that Justice Corliss mentions in her book, Rebuilding Justice, the commissions that are actually populated by a majority of non-lawyers, and that is citizen representatives from a diverse constituency, tend to remove the issue of partisanship, because Justice Corliss's book also points out a gubernatorial appointment system is prone to an equal problematic partisanship of partisan elections, or what we see on the federal level today. The exact same problem with the solution that is being sought regarding partisan elections is equated to a pure gubernatorial appointment system. So I will tell the commission, the trial lawyers are opposed to any system that would provide an appointment that resides in the governor's office and reflects the federal system. When it comes to a commission, I think that the diversity necessary of membership on the commission, to answer Justice Jameson's question, there are legislative voices on this commission. You have the Senate side, you have the House side, you have representatives from courts at different levels. Those constituencies then create, according to at least the Colorado model, different appointees, of which the majority must be non-lawyers, and then reflect the diversity. So as Mr. Jones represented, I would tell you that if you move forward with that concept, the imperative is that the details need to be laid out, because if that leaves itself to the discretion of elected officials, to one party, to one sensibility, that commission, from our research and quite frankly from the published things that I think are relied on by the National Centers for State Courts, would suggest it's prone to the exact same problem. I would say that this commission is faced with as difficult a solution as can be found, and like I said at the beginning, it's confounded people for a long time. I do not want to say that TTLA stands in bold support of the status quo. We are here to assist, and we'll work with the senators and the representatives on a difficult political issue that requires a constitutional amendment that, in the end of the day, asks the citizens of Texas to give up a fundamental right. That is a very difficult proposition. And there seem to be alternative solutions that may not be the status quo, but do not reflect that. This is not firing a head coach without knowing who you're going to hire. I think we can all agree that John Makovic needed to go before we knew who was coming in. This isn't the same situation. So before a total dismissal of the status quo because of the problems, and they are real problems. Let me say on behalf of TTLA entire membership and myself personally, the problems with the current system are manifest. However, a dismantling and a disregard for a constitutional right that has existed for some period of time and asking the legislative will for that is a difficult one that ought to be entered very carefully before other alternatives to such a matter is entered. And so with that, I'll conclude.
Let me interrupt just a minute. I want to leave some time for questions, if I may. First of all, obviously you're from Harris County, and we have in excess of 50 judges on the ballot in most instances. Assuming we go forward with an election system, how do we educate our voters as to who is a judge who's performing up to applicable standards, judicial temperament, courtesy with litigants, that type thing? I mean, how do we educate our voters? And I'll be honest with you, I don't even know who all of our civil judges are. I know the names, but that's really about all I know. How do we go about doing that? There's even been a suggestion in the literature that we put incumbent before a judge's name on the ballot. Well, of course, you know, the contrary view is, well, no, that's putting your hand on the scale and giving the incumbent a little bit of an advantage. So how do we educate our voters?
It's a great question, Mr. Chairman. And again, just because I've studied it as a resource before coming to the commission, as part of that O'Connor system that you would see reflected in the practice in Colorado or Utah, there could be something taken from it that is not necessarily part of, but still in part of an elected system. There is a judicial qualification review committee created by the state legislature that basically for 2 years grades a judge's paper on exactly the metrics that you're talking about, the way they interact with parties, the way they are considered by the people that practice in front of them, both parties and lawyers, staff, the quality of moving their docket, and that issues a report. Now, we live in an age with a lot of data, but sometimes not a lot of information. How do you get that out to voters for an educated decision? This, as the members of the legislature will know, among other things that the commission is talking about, carries a fiscal note, but it serves the interest. And so if you had some systematic review of exactly the metrics you're talking about over a period of time, you could then have that publication available. And again, you know, this shutdown has kind of proven our overwhelmed nature to the information available on the internet. But whether it be through county clerks or through the Secretary of State, whether it be in writing, which is more expensive than a website, how does that report card get out? And that's something that can be analyzed short of that, because Mr. Chairman, I know exactly what you're talking about. Getting all the way down to criminal court, criminal county court elections is a difficult process. But again, whether it be, we've suffered some sweeps, and that is a sad ramification of the system that we have. But it is dangerous because of those particular partisan outcomes, to throw out a constitutional right that may not exist in the same level in a different county. And that's the difficulty.
Okay. Thank you. Members of the commission, questions, please. I have one more question, if I may. You mentioned the commission. Assuming that that's what we recommend, just to be clear, would the TTLA be in favor of a commission that simply nominates potential judicial candidates to the governor, or would this commission, in your view, be one that actually names and identifies and in effect appoints the new judges?
So let me be clear. TTLA is not at this time in favor of a nominating commission appointment system. There is a unique distinction that you're drawing, and it's reflected, for example, in the practice in Colorado versus the practice in Utah or California, right? Where the governor office vets and then a commission vets. Again, there's so many different ways to do this, Mr. Chairman, that it is fascinating to study. Personally, I would say not on behalf of the association. From my perspective, an independent commission that is responsible for considering the candidates that leads to a nomination, which is then approved by the legislature in some process or accepted by the governor's office. But as I read the literature, it has suggested over and over again that the problems raised by partisan elections are not solved by a partisan nomination process. And Judge Jameson has raised this issue on the pinch point. My personal opinion would be a nonpartisan, open, transparent commission that is responsible for the nomination is the better practice. But that is, again, Mr. Chairman, a personal vote.
Okay, thank you very much. That's helpful. Any other member of the commission have a question?
I do have one question. Mr. Perdue, thank you for coming and for your very excellent preparation for your presentation today. I just have one question, and that is, would you agree or not that a commission, however it is organized, if the legislature were to do that or and constitutional amendment passed, would you agree that a commission would be unlikely to nominate for a judicial office a person who was under indictment or a trial or appellate nominee who had no experience ever trying a case or arguing appeal to the court that they're trying to be part of?
I think a nonpartisan commission of people who are interested in serving justice would not.
So do you think, so if we were to come up with a nonpartisan commission that was interested in serving justice, would you think that would be a superior form for judicial selection than a system in which the types of individuals I just mentioned are elected to that role?
So almost as a judicial candidate, you're almost asking me to comment about a case or a person that I could be in front of, Your Honor. And so, but taken as a hypothetical, there are people that put their name on the ballot for the right reason. We have some outstanding jurists across the state who got there by just putting their name in the hat and running. They were qualified. They chose it as a path to service. There are members such as that on this commission. So just the idea that because somebody has access to the ballot may open the door to those who are unqualified is an unfortunate side note. But as said earlier, I think almost every judge that I've had the honor to be in front of it was trying to do his or her best in the interest of justice. So you've offered from some very specific hypotheticals of which I am familiar. They are highly concerning and quite frankly, very problematic. There are qualification laws that it strikes me ought to address some of the hypotheticals that you are raising. And that goes back to the first point of agreement that I would say we join the other testifiers on behalf of the association as a whole, that judicial qualification as represented in the government code could be looked at and changed.
All right, we have time for one more question.
Yeah, Jim, this is Chip Babcock. For those of you who don't know, Jim and I serve on the Supreme Court Advisory Committee appointed by the Texas Supreme Court. And I can tell you, he is one of the most thoughtful members of that committee, and you can see why from his presentation today. My question, Jim, is this. If we retain, or if our recommendation is to retain the current election selection system, does TTLA have a view on whether or not there should be a change, or there should be some tweaking, or how we deal with?
Chip, you cut out on the last part of your question.
Funding the judicial campaign. They have a recommendation on how we fund the judicial campaigns. Should we change it or keep?
So, Mr. Chairman, I think I got the question, and thank you, Mr. Babcock. Yeah, I picked up on your theme and questionings, Mr. Babcock, regarding financing of elections, and I meant to address that before I finished up. I think as an association, it is a very interesting proposition. It is not one that I have either polled the membership or talked to the association as a whole. Having been involved in legislative processes, and the members of the legislature can certainly address this with their fellow members of the commission, you're talking about something with a pretty substantial fiscal note. It is very intriguing because it offers the opportunity to get money out of the elected system if you stuck with an elected system. And so it has the opportunity to maintain people's rights to vote, but also remove this question of the influence of money. And it's certainly something that would need to be studied. I can't lend support to it without that. And I would lend our efforts to work with the commission and the legislatures on the proposition, understanding that legislative council at some point is going to look at it to figure out what the cost of that may be. But it is a very intriguing solution that changes the status quo without necessarily throwing out our constitutional right.
Thanks very much.
All right, let me just add one short question, if I may. If we need additional input from TTLA with respect to what we're considering, would we work through you, Mr. Perdue, or would it be someone else?
So I'm a foolish volunteer in this position, Mr. Chairman. But I think you and the members of the commission know where to find me or Mr. Fields, who is our chief executive of public affairs, and either one of us would be the line of communication and ready, willing to assist in any way we can.
Great. Thank you very much for your very thoughtful presentation. And I think it's probably likely we'll be in touch.
Thank you, Mr. Chairman.
Thank you so much. All right, our final presenter today is Kent Reuter from the appellate section of the State Bar of Texas. Kent, you're on.
Thank you. Thank you, Mr. Chairman, and thank you to the commission for the invitation to be here in my capacity as chair of the appellate section of the State Bar of Texas.
And by the way, Lynn Liberato is so glad you're in the office.
In my office. The selection of appellate judges in particular is a matter of great importance to the more than 2,000 lawyers and judges who are members of the appellate section. And so we appreciate the opportunity to address this topic specifically as it pertains to our appellate courts. Our members' strong interest in this subject, I think, is reflected in the response to the survey that is summarized in the written report that I hope you all have seen, and also that I will be discussing this morning. A total of 546 appellate section members completed this survey, and 167 of them additionally submitted written comments to the commission. Because I'm here this morning on behalf of a section of the State Bar of Texas, and there are constraints on the bar taking positions on political issues or potentially political issues, I do need to be clear that the views presented in this survey reflect the opinions of individual members of the appellate section, which is a voluntary association of lawyers and judges, and not the section itself. The survey also does not represent my personal views or any position of the board of directors, the executive committee, or the general membership of the State Bar of Texas. That said, the survey that we designed included 4 questions, and the first asked participants to consider 7 common concerns about various methods of judicial selection and rate their importance. And so those responses are tabulated on page 2 of our report. And in the report, we ranked the responses according to the percentage of participants who rated each potential concern as either very important or extremely important. And the most important concern that participants had was the selection of judges, appellate judges, who lack relevant experience or qualifications, with 88.3% of the survey respondents rating that as either very important or extremely important. The second most important concern was the selection of judges based primarily on friendships or political relationships. Third was the potential of pressure on a sitting judge from his or her political party. Fourth was the actual or perceived influence of campaign contributions, which 66% thought was very or extremely important. Number 5 was the selection of judges who have high disapproval ratings from lawyers with 57%. Number 6 was a lack of diversity among appellate judges in Texas with 36%. And 7th out of 7 was a concern about the selection of judges who are not popular with voters, with 15.5% rating that as being either a very important or extremely important concern. You'll note that in the appendix to our report, the results to this question are broken down demographically according to each participant's role in the profession. For example, whether they are a sitting trial or appellate judge, a civil practitioner on either the plaintiff side, the defense side, or with a mixed practice, a criminal practitioner, either on the prosecution or defense side, etc. We also broke down answers according to the participants' number of years of practice, and finally, whether or not they are board certified by the Texas Board of Legal Specialization. Turning to question 2 on page 3, we asked participants to rank their preferences among 7 potential methods of selecting appellate judges. The preferred method of selecting appellate judges overall was nonpartisan elections. The second, third, fourth, and fifth preferred method of selecting appellate judges involved gubernatorial appointments for a term of years followed by elections. So the second preferred option was a gubernatorial appointment followed by nonpartisan elections. Third, retention elections. Fourth, a partisan election at the end of the first term followed by retention elections. And fifth was a gubernatorial appointment followed by partisan elections. Number 6 on the list of preferred methods of selecting appellate judges was partisan elections, and 7th out of 7 was the option for a gubernatorial lifetime appointment subject to confirmation by the Texas legislature, so essentially the federal system. And with this question as well, the results are broken down by demographics in the appendix to our report. I should note that we included only 7 options in question number 2, purely for the sake of keeping the survey brief and manageable and encouraging as many participants as we could to complete the survey. Of course, we are well aware that these 7 options are not the only 7 methods of selecting appellate judges. And of course, we're also aware that each of these options comes in many permutations. And so I'm going to be, I believe, the 3rd speaker today to use the phrase that the devil is in the details, but it is very true. And because of this, in the instructions to question 2 in our survey, we invited participants to specifically describe their preferred method for selecting appellate judges in their written comments. And as you'll see in the written report, many of the participants took us up on that offer and did so. One of the most important permutations for any of these options is certainly the potential involvement of a bipartisan judicial qualifications committee of some sort. And so we specifically asked about this possibility in the 3rd and 4th questions of our survey. And as it turned out, this possibility seems to have particular significance given, as we saw in question 1, that the most pressing concern about appellate judicial selection, according to our survey participants, was the selection of judges who lack relevant experience or qualifications. So in the 3rd question on page 4 of the written report, participants were asked whether they believe that a bipartisan judicial qualifications committee would fairly and objectively assess the qualifications of potential appellate judges without regard to political considerations. 54.5% answered this question yes, 39.2% answered the question no, and 6.3% had no opinion. In the final question, question 4 on page 5 of the report, participants were asked whether the state of Texas should require that any potential appellate judge be approved by a bipartisan judicial qualifications committee as a prerequisite to being either appointed or being included on a ballot. And the positive responses to this question were a little bit higher. 62% of respondents answered yes to this question, 31.4% said no, and 6.6% 6% had no opinion. Finally, as I mentioned, we did invite participants to provide any comments that they wanted to submit for consideration by the commission. I'm not going to make any attempt to summarize the 167 written comments this morning, except that I will note they reflect a broad variety of opinions. In many cases, I think they really reflect that the authors have thought very deeply about these topics and are very passionate in the views that they hold. And so all of those comments are set forth on pages 6 through 38 of the report, and I commend them to your review. That is a summary of our report. I'd certainly be glad to answer any questions the commission may have about either the appellate section or the survey that we conducted.
Well, thank you very much. It's some very interesting material, and I want to compliment you on getting a very high percentage of your members responding to the survey. It's an abnormally high response rate, so you all did a good job in getting the word out. And perhaps the fact that there were only 4 questions may have been a factor in the large response. Let me begin with a question, and this has to do with question 4. And that is requiring that a potential judge be approved by a bipartisan judicial qualifications committee. What type of qualifications are we talking about? I guess it could be such things as, let's take somebody who's brand new, who's never been a judge before, who wants to be a judge. What qualifications, what do you ask them about? How long you've been practicing? What's your area of practice? I mean, are those the type questions you would try to get answers to?
There are, it's a great question because as you point out, qualifications can mean many different things. And I believe some of the comments in the survey specifically noted that it sort of depends on how you define qualifications. We did not get into that in the survey, thinking it would be sort of permutations upon permutations, and we did want to keep the survey brief in the interest of getting as broad of a cross-section of the appellate section to complete the survey as we could. So we did limit the survey. We also pestered our members bordering on harassment to complete the survey, but it was fairly effective. But the section has not taken a position on what the qualifications would be. Certainly, if it seems like there's considerable interest in exploring the idea of having some sort of bipartisan qualifications committee, I think the section would be very open to conducting a follow-up survey in which one of the questions could be, should the qualifications be the number of years of practicing law? Should it be board certification? Should it be having been lead counsel in a certain number of appeals in the Texas courts, or some combination of those?
Okay, and one more question, then I'll turn it over to the other members of the commission. On question 2, where you rank order of preference of the following very different systems, whether it's appointive system, election system, and so on, I notice that nonpartisan elections is ranked number 1. What percentage of the persons responding to the survey noted that as their number 1 rank? Do you happen to know by any chance?
I don't have that in front of me. I do have a very lengthy Excel spreadsheet that was furnished by the State Bar of Texas, which we owe a significant debt to because they provided the mechanism for completing the survey or conducting the survey electronically. I can get that information to you. Yeah, I don't have it.
Would you mind doing that? Get the percentage for each one of these different 7 categories. I think the commissioners would like to know that information. So that would be very helpful. Thank you. All right, members of the commission, questions?
I think Chief Justice Phillips has a question, and then also Chief Justice Jefferson and Lynn also have their hands raised.
Chief Justice Phillips.
David asked my question, so I'll just say to the appellate section, thank you very much for this study, at least insofar as the appellate courts go, having a sense of where the problems are and what the solutions might be from 500 active appellate practitioners and judges will be very helpful to this commission and its work.
Thank you, Judge, and thank you for your work on this over many, many years. Appreciate it.
Yes, my question also kind of flows from, I think, how we are all impressed at the survey that was conducted. Has the section done a survey before on any topic, and if so, what was the participation rate? Because this seems very high, and the number of comments that were submitted seems extraordinarily unusual. It seems to me that there's a great amount of interest among the specialists. I don't know if they're all specialists, but people who are dedicated their careers to appellate practice. Is this unusual in your view?
I don't have a benchmark for the appellate section specifically. I do know that the folks who run the sections department over at the State Bar and the division of the State Bar that runs surveys in general were both floored by the number of responses that we had. One of the reasons that we're grateful to them is that they provided a mechanism by which we could ensure that only active members of the appellate section were completing the survey, while at the same time preserving or taking reasonable measures to preserve their anonymity. Sort of the system that the State Bar uses in State Bar elections, sort of a similar notion that you need to restrict the number of responses while ensuring anonymity. But I can only pass along their reaction that they thought having a response rate above 25% for an electronic survey was stupendous. And I think the 167 written comments, I do hope that the commission will take those into account, because many of them are lengthy, thoughtful, and contain comments that reflect that the authors have studied the academic literature on this subject, are familiar with the options in other states, and really have some good things to say.
Thank you.